Our first case of the morning is State v. Smalley. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
I'd like to reserve 5 minutes, Your
All
Honor.
right, very good. The court will note that. I will be keeping time up here. You can't see it, so I'll try to let you know when your time's about a minute left from your initial time. Give you a second to answer when you're coming up. I'll try to let you know if you're down about a minute left or more.
Thank you.
The argument is being recorded. When you present your argument, please make sure you come to the podium, introduce yourself. Please stay behind the podium so we can catch you on the recording and speak loud enough so the recording will pick you. To the extent you have to refer any victims or children or anyone, please make sure you use initials or some other designation like the victim or the child, if you would. Perfect. Other than that, we read your briefs and are ready to proceed whenever you are.
Thank you, Your Honor. Morning, Your Honors. Attorney John Kopasakis, 0090784. I represent Appellant Richard Smalley. Your Honor, we believe the court erred in two facets in this matter. Primarily, that the court inappropriately abused discretion in limiting the scope of the cross-examination of defense counsel and in its sentencing of Mr. Smalley. The primary issue that we believe that was an error here was that the court prevented defense counsel from expanding on questions to the victim in this matter and to the victim's significant other, Mr. McFadden, in regards to how the relationship was burned down. The entire premise of the defense was that the victim in this matter was lying to the police, that she had concocted this story in an attempt to reignite the relationship with the significant other, and that Mr. Smalley basically became a pawn in this game. Defense counsel, unfortunately, was limited in this aspect because he could not explore the domestic violence allegations that ended the relationship between the victim and the significant other.
Counsel, can you just explain to me what you mean became a pawn? How so?
Defense counsel's entire strategy here was that the victim was, in essence, guiding and kiting Mr. Smalley into a sexual interaction so that she can then later on contact the boyfriend to come rescue her after the fact, after the matter was initiated. And in fact, there is evidence to this effect in the sense that Mr. Smalley, upon being told to stop, got off the victim, assisted in contacting the significant other, guided the significant other to the victim in this matter, helped the victim leave the house, that he was basically just trying to be the good guy in the matter.
So that evidence was presented?
Partially. The evidence that was presented was the evidence of Mr. Smalley's appropriate actions. The evidence that was not presented was the evidence of the victim's tendency to lie. In this instance, there were only two parties that actually knew what happened in that bedroom on that night, and that was the victim and Mr. Smalley. They both know how this interaction began. They both know how this interaction broke down. Mr. Smalley has a constitutional right not to testify, so the only person who can testify is the victim in this matter. The defense counsel couldn't explore the credibility of the witness in this matter because he was not allowed to expand upon how the victim's testimony or how the victim in the future had manipulated and made allegations in the legal system to lie about other individuals.
But counsel, was it, if I remember correctly, didn't the trial court permit Mr. Smalley to ask both AE and the person who was her future husband that you're referring to about the reason for the end of their marriage? And they both, of course, had different positions on that.
They did, but they limited testimony.
Okay, but they were allowed to ask it. So what was it, can you explain to me why that wasn't, let's just say this court were to find that the trial court even assumes that the trial court improperly limited the cross-examination, wouldn't the record, doesn't that look like an error that would be harmless beyond a reasonable doubt?
I don't believe it would be harmless in the sense that it would prevent the counsel from actually impeaching witnesses. He was in essence not allowed to impeach the witness because he was allowed to ask the simple question, how did it break down? And he was allowed to create the basic of the contradiction that, she says that she was struck, he says it wasn't struck. He wasn't actually allowed to expand on that, to explore the differences in their story and the possibility that one of them is lying. In essence, the court had limited his statements down to both could be telling the truth, but they don't actually see it the same way. And the counsel wasn't allowed to explore the fact that one of these parties is lying, and it's, in counsel's opinion, most likely the victim in this matter, not the witness, the future husband in this matter.
Thank you.
Was there any exhibit or anything proffered that your client, that the attorney below wanted to introduce regarding impeachment purposes?
I don't believe there was any exhibits that were attempted to be proffered.
If I'm remembering correctly, and I may not be, but did the prosecutor then want to recall the victim in this case, and defense counsel below objected to that?
She did.
If that had happened, wouldn't defense counsel have the opportunity to impeach the victim at that point in time?
From the way I read the record, it seemed like that counsel was in essence hemmed in by what the judge had ordered in regards to the questioning, and wasn't going to go outside that hemming by the judge without risking a contempt of court finding. It's at one point, and it's almost a brief point in the record, that the court says, I don't expect you to go any further than this, or something to that effect. And Mr. Weatherly just, in essence, stops the line of questioning, doesn't press the judge any further.
Was that during the cross-examination of the victim, the initial cross-examination, when this discussion you're referencing occurred?
I believe so. I believe initially, yes. I believe it was during the cross-examination of the victim that it was stated, where are you going? I'm only leaving you this much room, and you're only going to go this far.
Was there some discussion when the state wanted to recall the victim about the cross-examination being limited at that point in time?
I don't believe there was any discussion, and I believe that may be a byproduct of the attorney understanding the rules of the road, so to say, that he was not going to get a second bite at an apple that he was already told he's not going to play. He's not allowed to go that way. The judge will not allow him to go that way. The judge is going to, in essence, abuse her discretion so that he cannot go any further than that, and he's not going to push that matter, because if he does, it's only going to end badly for either him or his client, and the only strategic way to deal with this mess that the judge has created is to attempt to stop that witness from coming in and basically running rickshaw in this case any further than it was already at that point. That being said, we believe that the defense counsel was inappropriately prevented from fully questioning the victim in this matter and fully questioning the state's witnesses in this matter, primarily because he was not allowed to impeach the witnesses to the extent that it would have been useful for his case. The court limited his impeachment to basically a disagreement to how they see the matter.
Counsel, you're saying witnesses as opposed to a witness?
It would be the victim and the significant other in this matter.
Okay.
So both of those two witnesses were, the defense counsel could not approach and properly question and impeach, which prevented him from actually making his case to the court.
But here, Mr. Smalley, wasn't the charge against him, didn't that require the state to prove that he engaged in sexual conduct with AE when he knew her ability to appraise the nature of, or the control of her conduct was substantially impaired? And wasn't there other evidence to that effect?
There was other evidence.
About a minute and 15 seconds left before you answer the question. So.
There was evidence to that effect. That evidence, though, would be rebuked by the victim by showing that the victim was lying about her level of intoxication and her willingness to engage in the sexual act. The whole matter is consent, and if the defense counsel can establish that the victim is lying in this matter, then she'd be lying about consent, which would then lower it down to prove beyond reasonable doubt. There would be reasonable doubt to imply that there was consent there, and he can make his case.
Thank you.
Thank you, Your Honor.
Thank you.
Good morning, Your Honors. Lindsay Poprocki for the state. Richard Smalley's stated assignment of error is that he was denied a meaningful opportunity to present a defense. That stated assignment of error is a roadmap and provides a guide to this court for what his assignment of error is, and his only claim to support this assertion is that the trial court improperly limited his defense counsel's ability to question the victim and a male witness regarding the nature of their relationship. But a thorough review of the record and an examination of this testimony in full context reviews that the trial court imposed no such limitation on Smalley's ability to question these witnesses, and counsel actually elicited the very testimony that he sought. At the very outset of the trial and during opening statements, Smalley's counsel laid the groundwork for his chosen defense that the victim in this case manufactured the allegations against Smalley of the sexual assault. Counsel then foreshadowed to the jury that the victim's relationship with that male witness was an important factor in the case, and that the reason why would be demonstrated and revealed by the evidence during the trial. Both the victim and that male witness testified that for several months prior to the sexual assault, they were in a romantic relationship. But by the time of the offense, their relationship had waned and that they were no longer dating. On cross-examination, defense counsel elicited testimony from the victim where she indicated that her relationship with that male changed several months after the sexual assault, when they began dating again and eventually married. The issue with the further questioning arose when defense began to ask the victim whether the couple was still married, and the state objected. A sidebar was held, and over objection of the state, defense counsel was permitted to question the victim as to how the relationship ended. Importantly, during that sidebar, defense counsel agreed to limit his own cross-examination to that single question. The victim then testified that she was no longer married to the male witness because he hit her. After this testimony came out, prior to resuming the second day of trial, the state made an oral motion in limine to prohibit further evidence in reference to the domestic violence issue raised in the victim's testimony. Defense counsel opposed that motion, specifically citing his desire to question the male witness later about the issue for purposes of impeachment. The trial court then denied the state's motion in limine. As he wanted to, on cross-examination of that male witness, defense counsel was able to elicit testimony over objection of the state again that his marriage to the victim was now over due to life stresses, and denied that he hit the victim and that her testimony was not true. In fact, the male 3 times denied the allegations that he hit the victim. This court must review the entirety of both witnesses' testimony in context in light of Smalley's argument. When it does so, this court will be left with the conclusion that there was simply no abuse of discretion by the trial court that limited Smalley's ability to present a defense. In fact, counsel was able to successfully elicit the very testimony he sought. Over the objection of the state from both the victim and her ex to support the defense theory that the victim manufactured the allegations of sexual assault against Smalley and had a propensity to lie. When the male witness testified that the victim's previous testimony that he hit her was not true, a contradiction was in fact exposed to the jury, which could have impacted her credibility in their minds. The testimony paved the way for the defense counsel's closing argument where he called the entire incident a setup, just as he had alluded that he would do in his openings. Counsel bases this assertion on a claim that the victim downplayed her relationship with Smalley to get back with him, and then accused him of domestic violence to get out of that relationship, just as she supposedly falsely accused Smalley of a sexual assault. Counsel was able to make these allegations and assertions based on evidence and testimony that came out during the trial. Ultimately, while the jury chose not to accept the defense presented by Smalley, it does not mean that he was denied a meaningful opportunity to present the defense he chose to pursue. The state submits that Smalley's second assignment of error raised in his brief, challenging his sentence, is simply not able to be reviewed by this court and should be rejected for that reason. The state would simply ask this court to apply its recent holding in Blackburn. And if there are no further questions,
Seeing none, thank you.
thank you.
You'll have your full 5 minutes, counsel.
Thank you, Your Honors. Your Honors, one of the last things that the jury is told is that counsel's statements are not testimony and it's not to be considered as evidence. While Mr. Weatherly did elaborate on his plan on closing arguments, unfortunately the evidence wasn't there because the court prevented Mr. Weatherly from exploring that evidence. While he had enough there to make that argument at the end of the day, the weight of the evidence was not able to be extracted from the witnesses because the court inappropriately limited his ability to question those witnesses. We believe that this matter was improperly, that this matter should be sent back for further proceedings because Mr. Smalley was not allowed to present a complete defense in this matter. His counsel was in essence fighting with one hand behind his back. While he did state that he would agree to limit his testimony, it was an agreement under the understanding that this is what the judge wants. As attorneys, we comply with the judge's orders. We're trained to do so. It is out of respect to the court and is out of respect to these proceedings. He did limit his questioning because the court had told him to limit his questioning. It was not a question, it was not an offer, it was not a, hey, do you think maybe you can limit? It was an order by the court. You were not to cross these lines, and he did not cross those lines. In regards to the sentencing matter, we believe that while the trial court does have broad discretion, and the appellate court has a limited discretion in reviewing sentencing, we believe that this court still has some discretion in reviewing the sentencing to ensure that the purposes and principles of sentencing were followed. And we believe that this court should at least look at this matter for that purposes. This is the offense, and Mr. Smalley has gotten the next to maximum possible sentence for the offense as is. If that were the case in any situation, then the mandatory sentence for any situation, any circumstance of this kind should be 4 years prison. The legislator has given a range to be found where the worst versions of this offense get higher levels and not as bad versions of this offense get lower levels. And this should be somewhere in that range, and this court gave the next to highest sentence on this matter. As such, Your Honor, we believe this matter should be sent back to the lower court for purposes of sentencing, and in addition, Your Honor, for further proceedings, because Mr. Smalley was not providing an appropriate defense and not allowed to have an appropriate defense. Thank you, Your Honors.
The court will take the matter under advisement and issue a decision in due course. That decision will be mailed to you at the court upon release and also be available on the High Supreme Court website. With that, on behalf of the court, I'd like to thank both of you for your presentation.